Let me say this with love. Having a U.S. citizen child does not automatically protect you from deportation. My name is Ruth Jean, and I am an immigration lawyer practicing in the United States. Now, this is one of the most dangerous immigration myths that I see. The myth is that people believe that once they have a baby born in the United States, for whatever reason, immigration cannot touch them. This is simply not true. Your child being a U.S. citizen does not automatically give you legal status. It does not stop removal or deportation proceedings, and it does not erase any prior immigration violations. Now, yes, a U.S. citizen child can petition for you, but only when that child turns 21 years old. And even then, even if they are able to petition for you at that point, if you entered without inspection, or if you have fraud issues, or if you have certain criminal history, you may still face serious barriers. I've seen parents placed in removal proceedings with U.S. citizen children, and I have seen families separated because they relied on this myth instead of building a strategy. Now, don't get me wrong. Does having a U.S. citizen child matter? Yes, of course it does. And in some cases, it can be a factor in cancellation of removal or other forms of relief. But it is not automatic. Immigration law does not operate on emotion, unfortunately. It operates on statutes, laws, regulations, and strategy. Now, as someone who came to this country by boat and is now an immigration attorney, I do understand how deeply families sacrifice for their children. That sacrifice was made for me. But love alone does not fix immigration status. You have to plan. You have to plan legally. Now, if you do have a U.S. citizen child and you don't have a status, don't wait. Don't assume you're safe just because you have a U.S. citizen child. Get informed. Get a real strategy. Protect your family right away.